Good evening, everyone, and welcome to this special speaker session organized by the YLAC Policy Collective of the Department of Political Science, Shaheed Bhagat Singh College. We are truly honored to have with us Dr. Adityanjee, a distinguished physician, psychiatrist, public policy thinker, and strategic affairs analyst whose work uniquely bridges medicine, human rights, and constitutional governance. An alumnus of Indian Institute of Medical Sciences, he completed his MBBS and MD in psychiatry, followed by a postgraduate diploma from the Institute of Psychiatry and MRC Psych from the Royal College of Psychiatrists. He later pursued advanced research at the Albert Einstein College of Medicine and served as an associate professor of psychiatry at the University of Minnesota Medical School. Over the course of his academic career, he has published more than 100 peer reviewed papers and led over 40 clinical research projects, making significant contributions to the field of psychiatry and public health. Beyond academia, Dr. Adityanjee has been actively engaged in public policy and human rights advocacy. He is the founding president of International Commission for Human Rights and Religious Freedom and leads the Council for Strategic Affairs, where his work brings an interdisciplinary perspective to the questions of constitutionalism, institutional accountability, and democratic reform. With this rare combination of expertise in medicine, policy, and governance, he is uniquely positioned to speak to us today on the theme of judicial reforms in India. Sir, we are deeply grateful that you could join us today. Over to you, sir.
Thank you very much indeed for such a kind introduction, Komika. And I am very, very thankful and grateful to both you, Piyush, and Shaheed Bhagat Singh College for hosting me for this particular talk. It's a very sensitive subject currently, as you know. So we will try to steer away from controversy. And I decided to do a PowerPoint because every statement I make has a reference to it. There are dangers of getting strayed and getting into conflict with the judiciary, especially keeping in mind what is going on now. So in my PowerPoint, whatever statements are there, if anyone wants, there will be a reference available, but we don't want to try to get into more controversy. So I will run my PowerPoint. Let's move to the next slide, please. I'm going to take a historical approach. Uh, Recently, book was banned by NCRT, grade 8th book was banned by the Supreme Court, ostensibly because it scandalized the judiciary by teaching students about corruption in the judiciary. I doubt whether any of you have read that chapter, but I did read that chapter because it was available somehow to me. But problems like this have been there for a long period of time. In 2015, the 99th Amendment to the Indian Constitution was invalidated by the Supreme Court, which tried to put a National Judicial Appointment Commission. So there have been issues in which there are three branches of state, as you know: judiciary, executive, and the legislative branch. And of course, the fourth branch is the press, which is the watchdog for those. In any democracy, the three branches or the three pillars of the democracy are co-equal branches. They have their own jurisdiction. Somehow that balance seems to have been lost over a period of time in India, and there have been conflicts between judiciary versus executive and judiciary versus legislative branch. There are always tensions between executive and legislature, but in India, usually legislature follows what the executive is saying because of the parliamentarian system, but you have actually disruption of the houses of parliament, things like that. But we don't want to have dispute and conflict between three co-equal branches of the government. And unfortunately, that has been there. So we have to go into the history as to how we came to this situation, let's move on to the next slide and talk about how did we arrive at this situation. So if you see the next slide, it says Constituent Assembly of India. I think we have gone back in projection. Constituent Assembly of India was not elected directly by the electorate. Constituent Assembly was indirectly elected, and actually there were members from what is now Pakistan and Bangladesh in Constituent Assembly. So provincial legislative assemblies actually nominated 292 members, then princely states and other provinces nominated 93 and 4 members of Constituent Assembly. It was founded in December 6, 1946. India was not independent at that time. Constituent Assembly ceased operations on January 26, 1950. Not known to many people, the first draft of Indian Constitution was written by Dr. B.N. Rao. However, the chairperson of the drafting committee was Dr. B.R. Ambedkar. A majority of chunk of deliberations of the Constituent Assembly was on the draft constitution initially prepared by Dr. B.N. Rao and then updated by the drafting committee. There were amendments that were submitted. You can move on to the next one. And after a lot of debate, the final constitution was adopted. Decisions were taken by majority vote. Certain amendments were rejected, certain were, accepted. Constituent Assembly had 11 sessions. It sat for a total of 166 days. On November 26, 49, Constituent Assembly adopted the Constitution of India, which came into force January 26, 1950. And we follow that Constitution till now, although this is how the Constitution was formed. Significant thing is that members of the Constituent Assembly were not elected by people of India. India was not independent when Constituent Assembly was formed. These were nominated by legislative assemblies, the princely states, and a large chunk of the people who served in Constituent Assembly went to Pakistan and what we call Bangladesh. So there were people who contributed to Constitution of India whose allegiance is not to the Indian nation, and we always tend to forget that. So Indian Constitution's Article 124 states, Chief Justice of India and other judges of the Supreme Court are appointed by the President under Clause 2 of Article 124 of the Constitution. And it is mentioned in the Article 124 that appointment by the President is to be done after consultations with the judges of the Supreme Court as the President may deem necessary. So it just says consultation. Article 124 of the Constitution says establishment and constitution of Supreme Court. There shall be a Supreme Court of India, Constitution, Chief Justice of India, until Parliament by law prescribes a larger number of not more than 7 other judges. So that was the original thing. Now we have 34 judges, and every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such of the judges of the Supreme Court and of the High Courts and Senate and states as President may deem necessary for purpose, and shall hold office until he attains the age of 65. So judges have to be appointed by the head of the state, which is President, after consultation. It doesn't mean after mandate by the Supreme Court. Yes, Chief Justice of India shall always be consulted, and of course a judge may, by writing under his hand, address to the President, resign from his office, or a judge may be removed from his office in manner provided in clause 4 of the Article 124. So this is what the Constitution says. And then There's Article 127, which says if at any time there should not be a quorum of judges of the Supreme Court available to hold or continue any session of the court, Chief Justice of India may, with previous consent of the President and after consultation with the Chief Justice of High Courts, request in writing attendance at the sittings of the court as an ad hoc judge for such period as it may be necessary. So ultimately, the responsibility is with the President. That is what was in the Constitution, but things seems to have actually deviated from what was in the Constitution originally. So, how things change? In Golaknath versus State of Punjab case, the judgment reversed Supreme Court's earlier decision which held the Parliament's power to amend all parts of Constitution, including Part 3 of the Fundamental Rights. So the judgment in Golaknath case left Parliament with no power to curtail the fundamental rights. And at that time, the Chief Justice of India, Mr. K. Subbarao, had first invoked what was called doctrine of prospective overruling, and he actually imported this from the US law. It was not there in Indian law. So Parliament's power to amend the constitution was changed in Golaknath case. And then we have this case of Kesavananda Bharati versus State of Kerala in 1973. This was a landmark case in which Supreme Court outlined what is now called basic structure doctrine of the Indian Constitution. This case is also known as fundamental rights case. In this case, the court in a 7-6 decision asserted its right to strike down amendments to the Constitution that were in violation of the so-called fundamental architecture of the Constitution. So the basic structure doctrine forms the basis of power of Indian judiciary at this point in time to review and override amendments to the Constitution of India that are enacted by the Indian Parliament. And it's important to state that in the Constitution of India, which has been revised now up to 106 times, there's no mention of the basic structure of Constitution. It's a post hoc creation by the judiciary as things have evolved over a period of time, and it has given undue power over parliament to the judiciary. So elected parliament is not able to make laws, and if it does make laws, those can be overruled by the judiciary under basic structure doctrine. Then there are three judges cases, S.P. Gupta versus Union of India, 1981, also known as Judges Transfer Case, Supreme Court Advocates on Record Association versus Union of India, 1993, and a special reference of 1998. In these three judges case over the courts, the court evolved a principle of judicial independence to mean that no other branch of the state, including the legislature and executive, would have a say in the appointment of judges. The court then created what is now called collegium system, which has been in use since the judgment in the second judge case that was issued in 1993. Again, in Constitution of India, there's no mention of collegium system or in the successive amendments to the Constitution. So it is a creation by the judiciary post hoc after the Constitution was adopted and amended whatever number of times. Now, I may actually point it out that we have a very unique situation that India is the only democracy where judges appoint judges. Judiciary appoints its own, whereas in all other democracies, that decision lies with the executive. So, in two pillars out of the three pillars, in two pillars, there is some conflict. What has happened over a period of time that judiciary as a branch of the state has systematically encroached on the domain of the executive. Not only with the basic structure doctrine, not only with invocation of the collegial system, but by using a tool which is called PIL, public interest litigation. They started around 1979. And what has happened that every policy decision of the executive at this juncture is being reviewed by the judiciary because of public interest litigation, whether it is demonetization policy, whether it was purchase of Rafales, whether it was farmers' agitation, whether it was Shaheen Bagh, blockade of roads, whether it was Central Vista project, whether it was political allegations of use of a spyware called Pegasus, whether it was Agniveer scheme, pretty much in every executive domain, judiciary has been involved one way or the other because somebody files a public interest litigation. Judiciary chooses to entertain that litigation or prayer and then decides whether this executive policy will be allowed to continue or not. So we are having a situation that there's a head-on conflict between judiciary and executive, and it leads to actually lack of smooth governance and sometimes lawlessness, as students might have noticed if you were in Delhi during the time of Shaheen Bagh agitation and farmers agitation. It was total chaos and lawlessness. Nobody was responsible because executive hands were tied. So judiciary is basically running the administration of the state. Judiciary is also interfering in the armed forces' effectiveness to defend the nation by criticizing security decisions taken by the armed forces or by the executive. So again, we are going into uncharted territories that was not envisaged by the original constitution. So I'll give you an example of judiciary executive conflict. On August 14, 2014, the Supreme Court pulled up the government that had taken, its role only in May of 2014 on Ganga cleanup project. Justice T.S. Thakur said, where is the urgency in dealing with this matter? People are waiting. Your election manifesto says that cleaning of the Ganga would be done on war footing. Where is the urgency? No one is showing urgency. Justice Thakur did not stop there, and he also said, in what is being widely seen as a reference to the National Judicial Appointment Commission Bill of 2014, which was passed by Lok Sabha around the same time. Some issues ought to be on the back burner are being put on the front burner. So this was an attempt by the judiciary in, winning a brownie point because they didn't want the National Judicial Appointment Bill to be passed into law. They started chastising the executive on a different matter and said that, you have been dealing with this for 18 years. Well, government of India was dealing with this 18 years, but this government had come only 3 months ago. So there is something does not jive very well why this was mentioned. So let's talk about the collegium system evolution. As I've said, there was no mention of collegium in the constitution. Basically, it is perceived as a crony system of judicial elite for the elite and by the elite. It is stated that there are certain number of families, judicial families, that perpetuate by family connections or other connections appointments into the judiciary, higher judiciary. So National Judicial Appointment Commission Act was passed in 2014. Commission was established by amending the Constitution of India through the 99th Constitutional Amendment, and it was passed by Lok Sabha, Rajya Sabha, and then it was, given assent by the president and subsequently ratified by a number of state legislatures as required, but it was not allowed to be implemented for a single day because there was a public interest litigation and the court invalidated that it is against the basic structure of the constitution. The judiciary legislature conflict have also been seen. They have been seen from 1960s. In UP Assembly case, there was judiciary versus legislature, a story from 1964. I've given the reference. So, in the history of Indian democracy, the constitutional crisis in Uttar Pradesh in 1964 was the earliest example of a confrontation between the judiciary and the legislature that led to derailment of the governance apple cart. And again, this kind of conflict continues because Supreme Court from bench has lamented that the legislature does not make good laws. They need to make good laws. So we have ongoing conflict. Then there's a judiciary public conflict. Judiciary is also upset with the public about making critical comments on social media platforms. That raises the question. We are living in a totally new world. Social media platforms have empowered citizens to convey their feelings. Other pillars of the governance of the state, whether that is legislature or executive, are heavily criticized on the social media by the citizens of the country. And they take it in their face value, in their stride. If you are in the kitchen, you face the heat. But judiciary is somewhat sensitive about it. Judiciary wants the executive and the agency of the state to prosecute people, citizens of the nation, criticizing judiciary on the social media. And I think that is an overreach. So there was a case in which Andhra Pradesh High Court directed CBI to probe a person who was living abroad for jibes against judges, and I've actually given you the reference there, which came in Deccan Herald. So are you going to, there are like 194 countries, and if people of Indian origin are living there and they make some comment, are you going to go there and arrest those people and bring them to India? Then there's an issue of judicial entitlements and abuse of privilege. There has been a system, unfortunately, of creation of post-retirement jobs by the Supreme Court. So you retire at age 65, you get your pension and other benefits because you had a tenure. But a number of statutory commissions have been created by the Supreme Court, which have only retired judges as chairpersons. So, in other words, retired judges are being given privileges and pelf, government money, offices, chauffeur driven cars for chairing these commissions. And I think that is an abuse of power by retired judges. I'll give you one example. Justice Manmohan Singh Liverhans, he chaired a commission that was about raising of the mosque or the disputed structure in Ayodhya. This commission was supposed to give its finding within 6 months. It kept asking for extensions for 18 years, and during those 18 years, retired Justice MMS Liverhans continued to have a government bungalow, a chauffeur-driven car, secretarial staff, and salary post-retirement while drawing his pension. I mean, this is blatant abuse of the government resources, basically people's resources. We have laws to curb freedom of expression. If you see globally, there are so-called blasphemy laws in 74 countries, and most of these countries are member of a group called OIC, Organization of Islamic Countries, and some from Christian countries. There are what I call less majesty law in Thailand, where you can be imprisoned for more than 10 years for saying anything insulting about the king or the monarchy. Now, what is happening in Thailand that successive governments have been destabilized by political adversaries for using this less majesty law. And there is what is called King's Party, a party of the establishment that cannot win the elections, but then it maneuvers and makes the executive or the prime minister as if Prime Minister has violated the lèse majesty law. Now we are seeing an Indian law parallels to the so-called blasphemy laws and the lèse majesty law. We have this contempt of court doctrine in India, which has chilling effect on highlighting corruption in the judiciary. Because if anyone wants to highlight corruption in judiciary, you are under threat of contempt of court because you are quote unquote scandalizing the court. So latest example is this banning of NCRT book for 8th grade students. And it was not even just about corruption in judiciary, it was how the judicial system functions in India. So I think we are getting into very, very difficult territory of the doctrine of contempt of court. It needs to be redefined and there should be very strict parameters for it. It cannot be open-ended. Speaking the truth must not be the ground for judicial punishment after invoking the doctrine of contempt of court. It is a regressive doctrine. It must be repealed or scope must be narrowed or restricted. Unfortunately, in India, doctrine of contempt of court, you cannot take the defense that I spoke the truth. Truth is not the defense. You can still be hauled up, jailed, sent to prison for contempt of the court if you spoke the truth. So contempt of court doctrine in India is akin to lèse majesty doctrine or law in Thailand and blasphemy laws in OIC countries that you can be automatically jailed for criticizing a religion or a prophet or something like that. In contemporary situation, there is a perception that judiciary is biased in favor of rich and famous because bail applications are being taken on phone, especially in two very famous cases, personalities. One was Teesta Setalwar and second was Salman Khan. At 2 a.m. on phone bail applications were taken and these individuals were bailed out. In fact, all the PILs that were filed by Teesta Setalwar were taken up by a bench headed by one particular judge in Gujarat High Court, that was Justice Aftab Alam, and a former Justice S.N. Soni of Gujarat High Court and former Lokayukta of Gujarat had to write a letter to Chief Justice S.H. Kapadia to stop this bench fixing, that all the PILs were being somehow sent to Justice Aftab's columns course. Also, what is happening is that court is taking suo moto cognizance of certain issues at a very alarming speed. So, in other words, by taking suo moto cognizance, you are influencing the executive decision when you should not be doing that. And there is definitely grandstanding from the pulpit. In Nupur Sharma case, oral observations by two judge bench of Justice J.B. Pardiwala and Justice Suryakant basically invited violence against this particular person. So we are seeing actually abuse of PIL system was not there in the original constitution, which was created in 1979 by a court judgment, and it fails in certain cases the so-called smell test. So collegium system has a lot of problems. It looks like that it has hijacked the constitution by Supreme Court. It is said by Justice R.S. Sodhi. It is considered opaque and arbitrary. There are no criteria. It encourages nepotism. It is ineffective in weeding out corruption. And there is so-called uncle judge syndrome. So what do we mean by uncle judge syndrome? We have situations that son of a chief justice eventually tends to become chief justice. We have two chief justices of India by last name Chandrachud. There was a case of a lawyer by name Saurabh Kirpal. His name was proposed by a collegium more than once for Delhi High Court. Now, the government of the day did not want that recommendation to be implemented because there were adverse findings by research and analysis wing about security issues. This attorney or lawyer is in a live-in relationship with a foreign diplomat who has been staying in India for extended period of time. And Supreme Court did not consider that as an issue. There were reservations by the executive based on the research and analysis wing report R&AW. Now, Saurabh Kirpal is the son of a former Chief Justice of India called, his name was Justice B.N. Kirpal. And Justice B.N. Kirpal had recommended the name of Justice Chandrachud, the younger one who retired recently, into the higher judiciary. So you have dynastic appointments from judicial dynasties. When people are appointed to the higher judiciary, in India, the system is that judicial service versus bar appointees. So the ratio is that only if you have 100 judges being appointed into high courts, 15 will come from judicial services and 85 are coming from bar appointees. And that creates a problem. To my mind, this ratio should be brought to 50-50. Judicial officers of the state, they go through competitive exams run by the states, and then they have their experience as working as magistrate, session judge, etc., etc. Why cannot they be promoted in a higher ratio? Why do we need only lawyers who can manipulate the system to be recommended to the higher judiciary? So there is an example, Chief Justice of India, Altamas Kabir, during his own tenure, his sister as a bar appointee was elevated to High Court judge status in Calcutta High Court. And this sister of Justice Altamas Kabir had dealt with only 3 cases in a year with an annual income of only rupees 86,000. So she was not a legal bright luminary to be elevated to the High Court. And then Gujarat High Court Chief Justice Bhaskar Bhattacharya alleged that Chief Justice of India, Altamas Kabir, had done so, and the Chief Justice denied. So you have the story published in Times of India between, two justices making allegations and counter allegations about nepotism. So again, talking about opacity in the collegium system, Chief Justice S.H. Kapadia in 2010 sent back names of 5 lawyers recommended for elevation as judge by Delhi High Court Collegium. Why it happened? Because names had been recommended by the Delhi High Court Collegium, headed by Chief Justice A.P. Shah, and in fact, these names were recommended just few days before Justice Shah was going to retire. And these 5 lawyers were Abhinav Vashisht, Rajiv Virmani, Anasuya Salwan, Meenakshi Arora, and Maninder Acharya. And there was a name of a district and session judge for elevation to High Court bench. Similarly, Saurabh Kirpal's name was not forwarded by government owing to security considerations, despite, collegium insisting that he must be. They did not actually view the foreign connections as a, red flag. We have problems within the judiciary. So there was a famous Supreme Court Justices press conference. 4 senior judges of Supreme Court of India called a press conference on January 12, 2018. And these judges were Justice Chalameshwar, Justice Gogoi, Justice Madan Lokur, and Justice Kurian Joseph. They expressed displeasure against then Chief Justice Deepak Mishra about assigning cases. And they claimed that junior justices were being assigned cases, bypassing them. Their assertion was that Chief Justice is only the first among equals and nothing more, nothing less. They stated that they are speaking out only because the democracy will not survive if judiciary is not impartial. And they wrote a letter to Chief Justice of India, Deepak Mishra, at that time, 2 months prior to this case conference. And I put a picture of this particular case conference. This was very unique in Indian judicial history that the sitting judges of Supreme Court are holding a press conference against the Chief Justice of India. And of course, there have been instances of corruption in the higher judiciary. There are numerous allegations of corruption in high courts and Supreme Court. There was a legal luminary who asserted that half of the Chief Justice of India were corrupt. And the name of that person is actually Prashant Bhushan. And he based it on a statement by another former Chief Justice of India, Justice Bharucha. And what is said that the benches are fixed, outcomes are fixed, there are double standards, there's manipulation of roster by the court's registrar, just like in Teesta Setalwad case, that all the PILs and cases filed by Teesta Setalwad went to Justice Aftab Alam. And we have situation now that judges are accusing out of fear in cases related to West Bengal post-poll violence, whether it is in High Court of Calcutta High Court or Supreme Court. Certain justices accused themselves because they were afraid. So I talked about the Justice Almas Kabir's nomination by collegium of his sister. And then just High Court Justice Bhaskar Bhattacharya made those allegations, and you have the reference there in Times of India. There was a very interesting case, and residents of Delhi will know that a few years ago there was a Chief Justice Y.S. Sabharwal. His tenure was known for direct instructions by the Supreme Court to Municipal Commissioner of Delhi to demolish shops in residential areas. And now that is perfectly fine, that there should not be shops in the residential areas because residential area peace is sort of disturbed. But if you look at most of the story in detail, there's almost a frenzy by which small shops were being demolished at the direction of Supreme Court, at the direction of Chief Justice, to the Municipal Commissioner of Delhi. So what was the conflict of interest? Just Chief Justice Sabharwal's two sons owned shopping malls in Gurgaon, and they were using the home address of Chief Justice, which is the official residence of the Chief Justice, to do their own business. Now we have this situation. So judiciary is perhaps having conflict of interest. I think we have to understand that judicial corruption in lower judiciary is a reality. Corruption in India is a reality, whatever branch of governance you are in, whether it is judiciary, whether it is executive, whether it is legislature. Fortunately, we have means of dealing with corruption in legislature and executive. You have elections, so you vote out the corrupt politicians, and corrupt politicians can be sent to jail. You have the example of Lalu Prasad Yadav. You have the example of Om Prakash Chautala. You have examples of recent politicians. But in situation of judicial corruption, you have no recourse to anything because the attempt is made to shove it under the carpet, and judiciary seems to be harming its own interests. There's a very famous example of Punjab and Haryana High Court judge. There were three judges, female judges with first name Nirmal. So this corruption case happened in 2008. 15 lakh rupees in cash was delivered to the home of a wrong judge. It was delivered to the judge Nirmal Kaur's home address. It was destined to be delivered to a different judge, and Justice Nirmal Kaur filed a complaint. And this case went up to 2025 from 2008. During this process, one accused died, and Justice Nirmal Yadav was finally acquitted on March 29, 2025. But the bottom line is that there is a smell test. It does not sound, smell good. That 15 lakh cash is delivered to a High Court judge's official residence for dealing in some property dealings. High officials are involved, and ultimately everyone is exonerated for whatever reason. We need easier mechanisms to prosecute corrupt judges, corrupt prosecutors, corrupt lawyers, corrupt government leaders, and of course, corrupt officials. You have currently Justice Yashwant Verma's case that is still not decided. He has refused to resign despite Supreme Court asking him to resign, and there's a pending impeachment inquiry going on. There are instances, I'm a physician, so if I make certain decisions and those decisions are not correct and patient dies, I can be hauled for medical malpractice. But there are, judicial cases in which judicial judgments have backfired and nobody is responsible. So in 1984, there was this infamous Bhopal gas tragedy Union Carbide case. And in that case, Supreme Court, led by Chief Justice R.S. Pathak and Justice Ahmadi, basically arrived at a public settlement of $475 million. Justice Ahmadi later on became the Chief Justice, and after his retirement, he himself became the chairperson of Bhopal Hospital Trust Fund for Victims, which is again very unusual. Previous chairperson, a UK lawyer, spent $2.5 million on refurbishing his house and office in London. And then subsequently, a PIL was filed for renegotiating the settlement, i.e. the Supreme Court wanted Government of India to pay additional compensation to the victims from GOI fund, Government of India funds, rather than from the settlement fund. You had another infamous case of two Italian Marines, Enrica Lexi, uh, in Enrica Lexi case in 212. Now, this case for murder of two fishermen by Italian Marines who were in India's exclusive economic zone, and they fired from a kind of civilian merchant marine vessel. And it was in a lower court. Supreme Court suo moto intervened, transferred the case to itself, gave bail to the Italian Marines who refused to come back. And finally, the Supreme Court closed the criminal proceedings in 2021 after 9 years, after a compensation of 10 crores was paid to the victim families and owner of the fishing boat. What essentially Supreme Court achieved by taking the case suo moto, giving bail to these Marines who fled to Italy and refused to come back despite entreaties by the court, we legalized the concept of blood money because there was no criminal case ever filed in Italy against these Marines. So, two innocent fishermen were killed by foreigner Marines, and we settled for blood money. Then the system is corrupt, so there is judicial political party nexus. There's a very famous saying in the popular media, in the movies and all, सरकार किसी भी हो लेकिन system तो हमारा है. There was a very famous saying previously, the law shall take its own course, and while the law was taking its course, the cases were bungled and accused were let free. In previous regime, a particular political leader said, during Congress party rule, we had a tradition of not enforcing the laws. So laws are on the books, but we would not enforce them. Now the same party is repeating the mantra, process is the punishment, i.e. nobody should be actually, hauled for corruption cases because process is the punishment. In judicial political party nexus, I'll give you several examples. There's a very famous case of Justice Baharul Islam, And there's a very famous or infamous case of Abhishek Manu Sanghavi's sex video in 2012, in which there's a discussion of helping a particular female lawyer for promotion to High Court bench. Similarly, there was a High Court Justice Abhay Thipse of Bombay High Court and Allahabad High Court, who after retiring actually joined Congress party. And speaking to Indian Express, Abhay Thipse said, "It is important to fight communal forces and communalism. That's why I'm joining Congress party." So if you were a judge and after retirement you join a political party, you don't have independence. Now this is the case of Justice Baharul Aslam. It is all taken from Wikipedia. When he was an attorney, when he was High Court judge, Supreme Court judge, when he retired, resigned from Supreme Court, wanted to fight, contest election from Barpeta, Assam for Lok Sabha as a Congress candidate. However, the elections were postponed. So then he was re-elected to Rajya Sabha. So you have a revolving door phenomena, a politician being appointed to judiciary at High Court level, Supreme Court level, resigns from Supreme Court, becomes an MP. This is actually a lot of conflict of interest. So again, judicial political party nexus, the revolving door phenomenon. Devidas Thakur started his law practice in J&K and became a junior to another attorney. After practicing there for 4 years, he moved to Jammu and was practicing in High Court of Jammu and Kashmir. He was promoted to the judge level of the High Court in 73. In 75, he was inducted as State Cabinet Minister after resigning as High Court judge. So a High Court judge wants to become a minister. He remained as Minister of Finance, Planning, Law, Food and Civil Supplies and Transport from 1975 to 1982. And after resigning from as a cabinet minister, he moved to Delhi, started the practice in Supreme Court as a senior advocate. He also served as Deputy Chief Minister of Jammu and Kashmir from 1984 to 1986. In 1990, he was appointed Governor of Assam and Arunachal Pradesh. So again, you have issues that politicians becoming judges and all that kind of thing. Let's talk about possible improvements in the collegium system. So you need to have a what is called memorandum of procedure, two-step process. Step one, search cum evaluation committee. There's a need for government nominees. And step two, collegium recommendations. Collegium should receive recommendations not just from lawyers and judicial fraternity and justices, but also from respective CMs, speakers, law ministers, public at large, law commission, bar associations. So the net should be cast much wider rather than by a small coterie of individuals. The discussions of and deliberations of collegium should be totally public and transparent, and they should be forwarded to the president, and consultation should not mean concurrence. Very important is this attorney Saurabh Kirpal case, in which he was in a living relation with a foreign diplomat for years. Usually diplomats are transferred after 2 or 3 years. In this case, that diplomat was living for more than a decade. So the issue is that judiciary has to reform itself. Nobody else can reform the judiciary. There was an instance when Supreme Court made IB and raw reports public during a matter, judicial matter. And I think that is sort of commented by then law minister, and you have the reference there. National Judicial Appointment Commission. In order to take away this controversy, in my mind, the Parliament can pass another amendment to Indian Constitution. It has been amended 106 times. No doubt the Supreme Court invalidated the 99th Amendment, but Another amendment can be brought before Parliament, rectifying the deficiencies that were there in the 2015 NJAC Act, which was deemed unconstitutional. If the Parliament passes a new National Judicial Appointment Commission bill into an act, President could sign the new bill, states could ratify the new constitutional amendment bill, and in my humble mind, the Honorable Supreme Court should keep an open mind on the possible new amendment instead of knee-jerk reaction of staying the act and automatic rejection. If such a bill is brought forth, the Honorable Supreme Court should not entertain public interest litigations by motivated quarters on that particular issue. What judicial reforms are required? You have recruitment at state level. We have in India very capable all India services. You have Indian Administrative Service, Indian Foreign Service, Indian Revenue Service, Indian Police Service. Time has come for India to have an all India judicial service in which the UPSC should do the competitive examinations in a very objective manner, and the states need a buy-in. Instead of doing local state level examinations, every state doing its own examination for judicial officers, let it be done at a national level. Nobody's interest will be harmed. Every candidate from every state will have equal opportunity for serving in the national judiciary. Candidates should opt for cadre in three states in rank order fashion. They should be ideally posted in the state in which the candidate is not domiciled. So if you are domiciled in Tamil Nadu, you shall not actually serve in that state because you will have conflict of interest. You could serve in Nagaland, you could serve in Assam, you could serve in Jammu and Kashmir. So you should never serve as a judicial officer in your own state because then you are subjected to political pressure and you are part of a nexus of political corruption. If we are going to have bar appointments, to change the lawyer to judicial service appointees to high judiciary in 50-50 ratio, not 15 to 85% ratio, because that 85% appointment from bars are actually leading to charges and allegations of nepotism, uncle judge syndrome, and dynastic succession in the judiciary. Judicial reform is not just reform of the judiciary or bar or laws. There's need for modernization of police force. Police reforms are a must. Training of investigators, detectives in evidence collection and preservation of crime scene, that is where most of the cases fail. There's need to upgrade the state level forensic labs. There must be automatic video recording of each deposition or affidavit or statement given to police or magistrates because a lot of time these statements are given, affidavits are given, and then the plea is made that they were done under duress. Pendency of cases in the Supreme Court. One suggestion is that Supreme Court should not entertain bail applications. It is the Supreme Court, it's a constitutional court, it should not be burdened with 2 a.m. by a phone application for bail of a criminal or something like that. It should be left for lower court and high courts. My humble request to the Supreme Court is that you cancel all your vacations in national interest. When we say pendency of cases, we cannot be doing finger pointing that government did not do, there are less number of judges. You have vacation time, you cancel that. Number of work days for Supreme Court must increase from current 193 days out of 365 days per year. Our hospitals function 365 days per year. Our Prime Minister serves 365 days a year. Our President serves 365 days a year. Our armed forces serve 365 days a year. Why should Supreme Court justices serve only 193 days? You need to increase the length of the workday in the court from 8 hours to maybe 10 hours. Delegate all the administrative work to non-judges. What is happening at that certain judges are being put on administrative duties. You can hire administrators with legal background. It's not rocket science. Any law graduate can do that administrative work. You don't need to burden the judges whose main task is judging, coming to verdict, should be burdened with the administrative work, and no more PILs till pendency of cases is over. You must write briefer judgments instead of 1,000 pages long judgments citing Shakespeare, US case law, and Pakistan's Supreme Court judgments. I mean, it's laughable when Indian judges cite Pakistani High Court's judgment. And of course, no oral observations while you are playing to the gallery and audience, because you made actually life of a particular citizen of India to threat. How do we deal with pendency of cases at state and local level? There must be time-bound prosecution in all civil cases. There must not be more than 3 continuations allowed in each case from either side, whether plaintiff or the defendants. The lawyers should be penalized for seeking repeated adjournments because of overload of cases. What is happening that lawyers find too many cases that they cannot handle. They'll say, I'm one day in this state, one day in that state. There should be a limit to number of cases that lawyers should take. Magistrates and judges should have their productivity appraisals and performance reviews like in corporate sector. In case of bail being given to violent offenders, the presiding officers of the jurisdictional court should have responsibility for repeat crimes by these offenders on bail. You are making a judgment. If you make a faulty judgment and this person goes and rapes another individual or kills another individual, shame on you. There needs to be more post-bail control and monitoring mechanisms in place in the judicial system in India, because once a person is given bail, he can do anything they want. Again, pendency of cases, no PILs till pendency is over. PILs must be admitted for only the rarest of the rare cases. There must be costs, realistic costs, adjudicated for frivolous PILs, because there's a PIL mill going on, PIL industry. And those lawyers who are running these PIL mills need to have penalty points, like just like as a driver, you make mistakes, there are points on your driver's license. Similarly, on lawyer's license, law license, there should be penalty points. There will be automatic penalties and fine for attorneys if they are filing too many frivolous PILs, which they are doing. And even the extreme step of suspension of law license by bar associations should be on the table. Otherwise, you will have, PIL attorneys running amok. So, what is the role of government? In this conundrum, everyone is at fault. It's not just fault of one pillar of the state. Biggest litigator in India is the government, state government and union government. There's a never ending appeal process. This must stop. Mindless appeals are done by bureaucrats. They must be curtailed. For small issues like pensions and all that sort of thing, they keep on appealing up to the Supreme Court. Do settlement of pending cases by arbitration. Of course, now in India there are arbitration mechanisms available which were not there earlier. A little bit about post-retirement appointments. Judges have the security of the tenure till they retire at age 65. After retirement, they get full pension. There's no need to ask for, lobby for post-retirement posts. No judicial officer, and particularly of the higher judiciary, should be assigned any posting in any establishment, including Rajya Sabha after their retirement, because it created a furor when Chief Justice Ranjan Gogoi was nominated to Rajya Sabha after post-retirement. There must be a cooling off period of at least 3 years post-retirement for appointments to various tribunals and commissions, and for contesting election for Lok Sabha or Rajya Sabha. Judiciary must not mandate that only retired judges alone can be chairpersons of various tribunals and commissions. Why cannot other people of eminence be chairpersons of these institutions? Why only retired judges? There is a history in India that one Chief Justice of India did not have a law degree, but he performed perfectly well. This was Chief Justice K.N. Vanchu. He was originally an ICS officer, but he had the expertise, and so there can be people with expertise from other domains who can serve as chairpersons of various commissions and tribunals. Assets and liabilities, all the judges of the Supreme Court, High Court, and state judicial officers must mandatorily disclose their net worth, their assets, liabilities every year, including those of their spouses and children. And that should include shareholdings, bank accounts, properties, including Benami properties, foreign bank accounts, gold, silver, diamond, and jewelry holdings. When you have somebody contesting for Lok Sabha, they have to put everything there in their affidavit. Why do judges shy away from declaring that? We come to the issue of impeachment of judges. In the history of independent India, so far no Supreme Court judge has ever been impeached. Impeachment has been attempted only 5 or 6 times since 1947. Justice Ramaswamy was the first judge against whom impeachment proceedings were initiated. In 1993, motion was brought up in Lok Sabha but failed to secure required two-third majority. And there was reason because the Congress party boycotted, so there was no required, although there was majority. Justice Soumitra Sen of Calcutta High Court resigned in 2011 after Rajya Sabha passed an impeachment motion against him. He was the first judge to have been impeached by the upper house for misconduct, but he resigned. In 2015, 58 members of Rajya Sabha moved an impeachment notice against Justice J.B. Pardiwala of the Gujarat High Court for his quote-unquote objectionable remarks on the issue of reservation. Didn't go anywhere. In 2017, Rajya Sabha MPs moved a motion to initiate impeachment proceedings against C.V. Nagarjuna Reddy of High Court for Andhra Pradesh and Telangana. And similarly, in March 2018, opposition parties signed a draft proposal for moving an impeachment motion against Deepak Mishra, the Chief Justice. The process of impeachment of judges is very cumbersome and slow. It is very ineffective remedy as system is gamed by the target of impeachment. You need a motion by at least 50 members of Rajya Sabha or 100 members of Lok Sabha. If that motion is passed by both the houses, you require consent from Chief Justice of India. So Chief Justice of India can veto any impeachment procedure. So there's a need to make impeachment process easier to weed out corrupt judges. And I'm making this in reference to Justice Yashwant Verma's case. Those who resign to obstruct the impeachment process, like Justice Soumitra Sen, they should forfeit their retirement benefits, because if they have charges of corruption, land grab, abuse of judicial office. There was just Justice P.D. Dinakaran, Chief Justice of Sikkim High Court, against whom Rajya Sabha chairman had set up a judicial panel to look into allegations of corruption. He resigned in July 2011 before impeachment process could be initiated against him. So by resigning, you subvert the process and you maintain your benefits. So what should be the further reforms? Ministry of Law needs to get its act together. It has done certain things. All the old colonial statutes from the rule book needs to be removed, introduce new and appropriately written laws. Bharatiya Nyaya Samhita is a good beginning, but it's just a beginning. It's not the end. It needs to be revised further. Every law should have a sunset clause or a date for review, because in Indian situation we know that laws are abused. Lawmaking should be left to the parliament, not to the judges. It's only in India that judges are making the laws, not parliamentarians. Judges are directing the parliament to make laws. Judges make laws themselves and parliament just rubber stamps them. There must not be automatic arrest in certain cases. We have non-bailable offences with automatic arrest. We know how much 498A, the Anti-Dowry Act, has been misused. Let the investigation be done in a time bound manner. You can say that, investigation will be done in 2 months, 3 months, whatever time. And if there is substantial charges, then only the accused should be arrested rather than automatically. So that way you take the criticism of process as the punishment. Because yes, people make frivolous charges in Indian situation, and these people are never brought to the book. That is my presentation, and I'll be happy to take questions. Uh, it's a very wide subject. I've tried to be very objective. I've cited the case laws, actual, case vienets in this presentation. I hope I'm not hauled for contempt of court by any branch of Indian judiciary. But I think we need to have a frank and open conversation for a new India, especially by young students. We cannot actually shove the debate under the carpet by banning books by Supreme Court, by being so thin-skinned that you cannot discuss judiciary. That is not sign of a mature democracy. In mature democracies, every pillar of the state is subject to accountability, critique, constructive critique, not scandalizing. And in case of India, also it should be so. Thank you very much indeed.
Thank you so much, sir, for the comprehensive projection. I think it has been, inherently insightful lecture we had so far, and I hope our audience find us as well. So yeah, thank you so much. See you in the next podcast.